Hello again, everyone, and welcome to Quigley on Divorce, a behind-the-scenes look. I'm your host, James Quigley, and I'm very pleased today to have with me one of our rising stars, top-tier associate attorney, Marcus Dominguez. Marcus, welcome.
Thank you. Thanks for having me, James.
So today's conversation is going to be about child support, and it kind of flows from the series we have spent the last couple of episodes talking about child-related issues, and this is sort of the perfect transition from child-related issues into the financial issues, which the next probably month or so we'll be dealing with financial issues in divorce. So kind of just as a starting point, Marcus, why don't you explain to the viewers, the listeners, in Illinois, there's been a shift in child support probably in, 2016?
Correct. Yep. New law in 2016.
Yep. And it went from the old days when I first started practicing 30 years ago, you just took a percentage of the payor's net income. You know, it was one child was 20%, two was 28%, and three was 32%, and so on. And it didn't really matter what the recipient spouse, or parent, I should say, was earning. It was all based upon what the payor's income was.
Yep.
So there's been a shift away from that. So why don't you explain kind of what that shift is and how it works now here in Illinois and in, quite frankly, a lot of the states across the country?
Yeah, so in 2016, Illinois joined the vast majority of states in adopting an income shares approach. And what that means is that the state of Illinois or a judge will now look at primarily three different factors: the income of one spouse or one parent, the income of the second spouse or second parent, and then what's the parenting schedule. In Illinois, we've decided that in order to receive a so-called discount on child support, the number of overnights one parent has to have is 146. And then, but the other information, the income, that part stays the same. So in Illinois, we impute it in what's called a formula. We have one spouse's income, one parent's income, the other spouse's income, other parent's income. And then what's the parenting schedule look like? How many overnights does one parent have with the other child? And in Illinois, back in the day, it used to be 20% of whoever basically didn't have the vast majority of the parenting time was the payer of child support. Now, there are some situations that even if you have the majority of parenting time, you can still pay child support. That's just basically what the factors and what the formula ends up spitting out.
Let me actually have you circle back on that. So that's an interesting point. That we actually have cases where, for example, we have one case.
We do.
It's gone on for quite some time, where our client, dad, the parties had a 50-50, and we went back. We had a large trial on that, and our client now has sole decision-making and the majority of parenting time. But because his income is so much greater than his ex-wife's, he actually pays child support to his ex-wife, even though he has more time.
That's correct. And so not only are there situations where even though you might have the majority parenting time, you will still be paying child support. Also, about 95% of our cases, we follow the guidelines, but there are certain cases where the judge looks at different things like lifestyle, a party's net worth versus income, and decides that the guidelines just don't really make sense for specific cases.
And that's something, again, it's a nuance, and this is behind the scenes, right? So understanding the formula doesn't always apply. What are the threshold benchmarks set forth in the statute that the court almost automatically has to apply the formula for?
So could you rephrase that question?
So the income threshold.
Right. So for example, if the income is $500,000 is what the statute says, that if you have two parties who the combined household income is $500,000 or less, the statute applies.
Yep.
But even then, I remember cases where we represented former basketball players who now they don't have an income, but they retired and they have substantial net worth. And so even in cases like that, the court might look at, well, okay, you're retired, but look at how much you have in the bank. Look at the lifestyle you provide, private planes, going on vacations to this child. Mm-hmm. And the court even then can look at the scenario and deviate from there.
So it's somewhat individualized. It's, like Marcus said, the vast majority of cases, even sometimes when you have household combined incomes in excess of $500,000, the formulas that we use there's an extrapolator such that the computer can run the formula on amounts even over $500,000. And oftentimes, courts adopt that. It's going to be more than if, someone making $500,000, but if someone's making $1 million and you plug that in, it's still going to spit out a support number that oftentimes the court uses. What Marcus is talking about is a very sort of nuanced approach, which is it's almost a needs-based type of an analysis. And so getting into one of the cases that we did try, we represented a woman who was not married to but had a child with an NBA basketball player, very well known, very wealthy. And he had just retired and says, I don't really have an income. And he did. He had some, the league paid him something for, being an ambassador of such, and maybe made $100,000 here and there and did some travel. But what the court looked at was, here's an individual that has millions, tens of millions of dollars in the bank, building a 25,000 square foot home, basketball court he had all the luxuries. And basically, they were trying to say that our client should basically get a few $1,000s a month. And one might think, well, how much does it really cost to raise a child? But that's not really what the issue is. It came down to standard of living. And the court, in that case, in awarding our client $14,000 a month in child support and making the NBA player pay a lot more of the direct pays, really came down to the question of lifestyle. Because the court was concerned that if you have one child who, like Marcus said, private jets, fancy homes, indoor basketball, a fleet of cars like you wouldn't believe, and here's mom in a bad apartment, driving a used car, that wouldn't be in the child's best interest. So there are those situations where a court can deviate, but they look at other factors then.
Right. Throughout Illinois law, even in the statute and through case law, it really looks at the public policy behind. They don't want a child to transitions are already hard going when a parenting schedule is established, but it gets even harder when the things that you can do and the lifestyle that you do with one parent is then vastly different with another parent. And so the court and the law really tries to craft child support in a way where the lifestyles that one parent can have versus another parent isn't drastically different.
So that's sort of an interesting nuance, just understanding that there can be a deviation from the formulaic guidelines, but the circumstances have to be somewhat unique, and it's usually in those situations where there's some significant wealth. It's interesting, and I'm going to shift a little bit into another sort of a behind-the-scenes kind of discussion on child support as it relates to prenuptial agreements. We just had a conversation with a client who had a prenuptial agreement and has been now blessed with a little baby boy. And so he's got a child. And Marcus, for the viewers and listeners, if you are doing a prenuptial agreement, are there things you can put in place as it relates to children into a prenuptial agreement that is already predetermined?
So the Illinois law does not allow any kind of parenting schedule, decision-making, or child support in a prenuptial agreement, or anything regarding who's going to pay attorney's fees, regarding litigation, regarding what a party believes is in their children's best interest. Public policy being that you shouldn't have financial considerations attached to child-related decisions. And so a prenuptial agreement can sometimes, for example, the individual we were meeting with, in the prenuptial agreement, there was a maintenance package that spouse would receive. And so in the event of a divorce, when you plug in the formula, the amount of money that you'd be getting from that package would be included as her income for child support. And that's also a difference as we talk about marital couples versus parentage cases. And one main difference is if you're also paying child support and maintenance, the maintenance that one spouse receives does get plugged back into the formula, which can significantly lower your child support amount, versus a parentage case, there is no maintenance. So it's just the parties' incomes, the parenting schedule, what does child support equal?
Yeah. And I think what's a good sort of nuanced part of what Marcus was saying is when you have a provision in your prenuptial agreement, and you should, that says each party pays his and her own, or each party to the marriage pays their own attorney's fees, that's great. However, once you have a child during the marriage, as it relates to any litigation over the child or about the child or child-related issues, those attorney's fees, it would be against public policy to, for example, in the case where I had, if you've got a woman who doesn't have really any wealth, and you've got someone else with great wealth, and then the person with no wealth isn't going to be able to have an attorney provide them with the legal resources they need. So there are situations where a court, and we're litigating a case right now where the husband has paid us handsomely because he primarily doesn't want to be reasonable. But in that case, he's arguing that there was an agreement that controls attorney's fees, but whether it does or it doesn't, it cannot apply to anything child-related, which is the bulk of the litigation in our case.
And piggyback off the public policy point, the reason why let's say in your prenuptial agreement, you set child support at $1,000 per month, but you're living and the child is accustomed to a $25,000 per month lifestyle, just like the public policy, how they don't want to transition. Well, that's the reasoning behind you can't carve out or have any provisions in a prenuptial agreement or postnuptial agreement pertaining to how much per month is child support going to be.
Yeah. And when we talk about child support, understand that's the actual amount that one parent pays to the other parent for child support is just a component of it. And the other components can include private school education, contribution to daycare expenses. In other words, if one of the parents, is going to work outside of the home and they need to have a nanny or a daycare or something, you could have an obligation above and beyond your child support, certainly medical expenses that aren't covered by insurance. And so sometimes what we try to do in cases is, first we look at the formula. And the formula, Marcus, explain how the formula deals in terms of who pays what of the other expenses beyond child support.
So outside of child support, the formula can also look at how expenses should be allocated between the parties. For example, it could be a pro rata basis where if one party's income makes up 66% of the household income, well, then a judge might look at that and say, okay, you're going to be making more in the future. We have child support carved out, but you should be paying 66% of the expenses to the other spouse's 33%. Likewise, if the parties' incomes are pretty equal, then a court might look at that and determine, okay, we're going to divide certain expenses equal.
Yeah, and I think that's the formula itself actually splits out those pro rata percentages so that after one parent pays the other parent the support, and even maintenance gets factored into
Correct.
that, whatever that money is flowing from one parent to the other, then they look at what percentage of the total combined income this person has versus that. And if it's like, if Marcus said, even after the spouse is paying child support to the other, that spouse is still left with 66% of the combined income. Very high likelihood that spouse is going to pay 60% of those other direct pays, activities, medical expenses, educational expenses. Again, educational expenses are a little more nuanced, right? You can't just all of a sudden say, hey, we're divorced, and 2 years later I'm sending our kid to, one of these very expensive private schools here in Chicago without an agreement. But if there's a situation where mom and dad get divorced and children have been in private schools, then the court can order the continuation of those as the best interest of children.
And also tied to that is decision making when we're talking about child-related expenses. Decision making, and if parties are in joint decision making or sole decision making, meaning does one parent sole have complete decision making authority over medical, educational, extracurricular, and religious decisions, or are these decisions made jointly, can impact how things are paid for. For example, if in a case two parties, they can't agree on the color of the sky, a judge might say, okay, we're going to have sole decision making for one parent. That parent then can make these decisions and sign children up, usually within a reasonable limit, for certain activities. Like, let's say, for example, the child wants to go to the more expensive ballet compared to soccer every other weekend, then that parent who doesn't have the decision making might be on the hook, even though they didn't agree, for that ballet class, given sole decision-making or joint decision-making.
Yeah. So the takeaway there is just be aware that if you're going into a process, whether it's a parentage action or a divorce, child support is going to be a number from one, and by the way, I should digress. A court, generally speaking, is not going to accept no child support unless both parents are really financially similarly situated and there's a very similar parenting schedule. You know, sometimes a court can intervene if one parent is, you know, abusive, for example, and they've got the other parent so intimidated saying, I don't want child support, that the court can come in and undercut that and say, well, that's not your decision to make. The benefit is to the child, and so the child needs to be supported. So be aware of that, but generally speaking, you go in, there's going to be a number from spouse A to spouse B or parent A to parent B, and in addition to that, there's going to be some contribution to the other expenses, the schools, the medical expenses, the activities, and so forth. So these are things that generally there's not a lot of litigation over these things, and there can be. In other words, when you have the situation where you're dealing with an athlete or somebody with such great wealth, and you know they've got their opinion as to what the number should be. But generally speaking, you know, this is not your hill to die on. This child support is not something where you should want to be going to court and paying a lot of lawyers. This is money that should be for the benefit of your children. So always keep that in mind. It is interesting. I want to go back to something, Marcus, that you referenced. When they modified or amended the statutes in 2016, when they made the income shares model the law in the state of Illinois, which again, they're very, very similar models in most states. What made it really interesting for us as practitioners is, for the first time, it became relevant in terms of the actual amount that you pay for child support based upon the schedule of overnights. And so as Marcus mentioned, what was the number, 148?
146.
146. So think about that. We get cases now where one parent oftentimes is fighting for what we consider a 9-5 schedule. And a 9-5 schedule means on a 14-day rotating basis, the one parent at least has 5 overnights. And if you combine that with, you know, your splitting of the vacations, spring break, your winter break, Thanksgiving vacation, and all these days off, you know, whatever, it becomes a fight for making sure my client gets that 146 overnights, because when that happens, it triggers within the formula itself a discount for the payor.
That's correct. And we don't pass any judgment regarding what someone's agenda is, but we do have some parents who know that 146, and they come to us and say, I just want my 50-50 schedule. I want to see my kid all the time, and I'll waive the 146. And when we put the number into the formula, just say I have 145 overnights, because they say, look, child support, I'm going to pay it. State of Illinois says it, but what's more important to me is the amount of time I have with my child, and I know my spouse is going to fight about the 146. I don't want to do so. I will pay above guideline child support. And then we see the reverse happen, where they have the calendar out, they're counting the number of days. Doesn't really matter what the schedule is, so as long as they get that 146 overnights, they're okay.
Yeah. And so that's just, that's one of those things where, as Marcus said, our job isn't to judge the people that come before us and what their motivations are, but it is our job to sort of, I think, give our recommendation and our advice to people. Because what happens oftentimes, if you're that individual that, listen, I look back to my early career, I mean, I couldn't have had a 50-50 schedule with the hours I was working, I mean, it just wasn't feasible. Sometimes I got home and the kids were asleep already, So if I were the guy then standing there saying, I want 50-50, well, how are you practically going to do that? And why are you even doing that? That's not good for the kids' routine. Well, it gets me a discount in my child support. You're going to look like a schmuck. And the judges, they're going to look at that motivation. They're going to look at, as you in terms of the credibility they assign to you. And that can bleed over into other issues in your case. So everyone has a right to pursue whatever, I mean, that's certainly a legal, valid cause of action to say, I want my child to be with me 50% of the time or more than 50% of the time. But you should look at historically what have you and the other parent done with your children, because that's in large part what the court's going to look at. And then what are your motivations for doing it? And if it's to save a few bucks, I guess what I would always encourage you to do, sit down with your lawyers, get somebody smart like Marcus, and you say, Marcus, run the formula for me. Run the formula for me with the 146 and without it. Okay, 50-50. What am I really saving in terms of actual dollars? Because if you get into litigation over this stuff, again, you're probably not going to look that great in the court's eyes. And the other thing is you're going to be paying tens of thousands of dollars to us to litigate, to save a couple of bucks, and it's money that otherwise could go to your kids. It engenders some goodwill in a case. It maybe says, hey, we agreed upon something. Let's go to the next issue and build upon that. So not saying you should not fight for parenting time. In fact, I think that in the one good thing about in 30 years ago versus today is, and I'll say dads, because 30 years ago it was really more a dad didn't really get as many opportunities to have a 50-50 schedule. And I think the world, the courts, the guardian ad litems, the people that do the evaluations have now sort of seen things differently, that both parents' involvement in a child's life is probably going to have a better outcome for the child if we can do that in a healthy way.
No question. And just bouncing off of James' point with the 146 overnights, let's say we're just running the formula. And if you gave us a call right now, I could have my laptop open, and on the phone, real time, I could be telling you, plugging in numbers, what your child support would look like. And oftentimes,
by the way, I couldn't. Let's be clear on that. So this is what Marcus does.
With James in the room, and we're all on the phone together, I can pull up and type in the formula. And not only do we do that with, okay, here's what we're looking at with 147 overnights, here's what it looks at with 145 overnights, but also, let's say over the past 5 years, your income has fluctuated, and your spouse wants to peg you on your highest year during that 5-year period of time. What we can also do is say, look, here's what support looks like in real time as we're talking with you. Let's say $250,000 was your best year. But if we average it out, you're closer to $210,000 over that same period of time. What we can do is we can say, okay, here's what child support looks like at $250,000, and here's what it looks like with you at $210,000. And that gives you better perspective to find out, okay, I'm really going to fight this? Are we going to meet at the middle of $230,000? How much difference does that make to want you to litigate or fight more about those different points?
And that's a really, really good point, too, because what's Marcus didn't get to was, if you're in a situation, say you're a business owner like we are, and you don't have just a set salary, right? What you make from year to year fluctuates. Okay. What the courts are going to do, and this is it's such a great concept, which we're able to do now. We couldn't do this back in the old days. It wasn't just a percentage; it was a number that was set at the percentage. And so if someone's income went up, you had to go back into court and say, I still want to apply that same 20%, but his income is greater, so now the 20% should be this number. Now, what you can do is you have somebody that, if you said, let's take an average income over 3 years or 5 years, whatever makes most sense, because sometimes, like COVID hit, right? We had people whose incomes plummeted, right? And so using the COVID year in a random sampling, maybe you want to pull that year out. We just had a client in, the guy said, I had a great year, I made over $1 million, but that's not normative. So maybe you take the high and the low out and you average the last ones. But either way, you come up with a base that we're going to pay child support. And if you're representing the individual who's collecting the child support, wait a minute. If he made $1 million last year, I want child support off of that. I don't want it off of $600,000. But if $600,000 was the average, oftentimes what's going to happen is we're going to set it off to $600,000, and there's going to be what's called a true-up at the end of the year. If the payor spouse's income that next year ended up being $780,000, great. You are paying support on $600,000, so there's a calculation, that's the true-up, that's going to have to be done on what would the spouse have paid if we had it at $780,000, and that spouse or that parent is going to owe the other parent the additional support in that year. We don't have to go to court. You probably need to work with the CPA, or you could call your lawyers back and we can help you with those computations. But it really is an equitable way to have a child support order that fairly and accurately supports the child off of a fluctuating income without having to go back to court. So the true-up is a really good concept. It does require people coming back together, and you know, sometimes there's a dispute in terms of how they run their formula versus this or that. But keep in mind that if you're a business owner, or if you have irregular income, the way you're paid off of commissions, it's not just a straight salary, there's ways we can handle that as well. So, you know, this was, again, as I mentioned, this was sort of our opportunity to transition from February's, you know, really focus on parenting issues, child-related issues, and this is sort of, you know, the antithesis of that, where we're now segueing from a child-related issue, which child support is, into the financial issues, which it is. And it's sort of interesting because even when we do our agreements, the allocation judgment, which in some states it's a parenting agreement, back in the days we called it a joint parenting agreement if the parties jointly decided things, but that allocation judgment just deals specifically with child-related issues, not financial issues. And that's where there's usually a marital settlement agreement, or if there's a parentage action, it's a separate financial agreement. Try to keep those issues separate when we present them to the court. So I'm hoping this was informative for you. You know, at any point in time, if you have questions about child support or child support modification, you can always contact us. My direct extension is 312-621-1225. Marcus, what's your direct?
312-621-1266.
And if you ever wanted to just look at our website, check out our profiles, Marcus has got a great picture. You can log on at www.beermannlaw.com, 2 E's, 2 N's in Beermann. And as always, we appreciate you following along and listening. If you ever have topics that you'd like for us to address in the podcast, happy to do that. Reach out to us, and we'll keep that in mind. Thanks again, and have a good one.